So the media, you start by challenges. So start by challenges. First of all, is that today, for the 4 or 5 days, we'll be having the training of judges on good governance and the rule of law. Yes, you said the court has been seen as a political court. It's not a political court, but that's the court which has been established by the treaty for the establishment of this type of community as a judicial organ of the community. So in November this year, the court will be having the 20th anniversary. And it is not a political court. It is a court which has been established by the partner states themselves in accordance with the treaty, but also in accordance with the Vienna Convention on the Law of the Treaties. So it is a judicial organ of the community which is in charge of interpreting, application, and compliance with the treaty. So since its establishment, so a number of cases have shown that the court has been making jurisprudence, and also the decision of the court. They have been, of course, the court does not have the powers on looking on the implementation, but the partner states have been implementing the decision of the court, because it is true that implementing of the decision of the court is by the goodwill of the government. But from its establishment, the partner states have been implementing the decision of the court, and we are confident that even tomorrow, after tomorrow, the partner states will keep on implementing the decisions of the court. Underfunding, if the court is being underfunded, that's a matter of time. We are sure that now we can say that we have been invited the Attorney General of Kenya, who is a member of the Council of Ministers, also a member of the Senate Council on Legal and Judicial Affairs, and also we are also the agenda of the court now has been being tabled to the council, and we are sure that underfunding will not continue. Will not continue because the court it belongs to the community, belongs to the partners, and we are sure the underfunding that is a matter of time.
There's also the question of the limits of the boundaries of the courts. I mean, what cases should the court handle? Because we have seen election petitions all the way up to it ends at the respective Supreme Court, like if it's the Kenya, and someone is satisfied because they are. What are the limits?
No, the court is not an appellate court over the partner states. It is not an appellate court over the partner states. But the mandate of the court, the decision of the court, is provided for under Article 27(2) of the treaty. 27(2) of the treaty. So, whatever is about interpretation, application, and observation of the treaty, it comes to the court. And the court has been entertaining the matters coming even from the superior courts of partner states, not as an appeal, but whenever the partner states judiciaries or courts made the judgments, and the litigants think that the judgment is not compliant with the treaty, they may come. And they have been coming to the East African Court of Justice, even if the judgments have been made by the Supreme Courts of the partner states, not as appeal, but to see if the judgments rendered are in conformity with the issue of good governance, the rule of law, judicial justice. So they have been coming, not as appeal, but in order to see if the judgments made are in compliance with the treaty. Yes, the issue of judges serving on ad hoc basis, that is an issue which is in a treaty. But we think we have been making some progress, and the last council, the registrar appeared to the council, and we have made some progress. Now the issue is being entertained by the Council of Ministers, and we hope that next council we say something on ad hoc basis, because we have the projects now. They have backlog cases in the court, and we think the judge could not continue coming in Arusha on ad hoc. So we are requesting that the judges be permanent in Arusha, because as we say now, we have only the judge president and the principal judge who are permanent in Arusha. But if you see the number of cases we are having now in the court, we think and we are sure that the service of the judges will be permanent. We are sure, because now we are making progress. We are making progress, and now the matter is being undertaken by the council. Then on the issue of the comments by partners, that is about also is about the individual independence of the court, because now, as we are saying, the bill it does not come from the court. The bill came from EALA as a private member's bill, but also it is for the benefit of the court. So we have been requesting the partners to give comments on that bill, and also because Kenya also is, but we are sure all partners will be giving their comments, including Kenya. There's no problem.